Hello and welcome. I'm Peter Afrasiabi, host of the Curious Lawyer CLE program series, and I'm a partner at the law firm of One LLP in Newport Beach, California. The Curious Lawyer is your fun and entertaining, educational and interesting, off-the-beaten-path CLE series. It's a chance for you to explore and learn about varied and very different areas of the law, perhaps places that have never intersected with your practice, but which can illuminate and round out your legal knowledge, and it can make you a fun, interesting person at a cocktail party too. So for that reason, if you check out all of our Curious Lawyer programs, you will see that we've covered things such as dog law, CIA law. Did you ever want to know where the famous saying, "I can't confirm or deny" came from? Turns out you'll find out in CIA law. We've covered space law. We've covered presidential pardon law, and if you want to figure out how to commit the perfect crime and get away with it in Yellowstone National Park, you should check out one of our programs on that. Now, you're here today for our Bill of Rights series that we're doing as part of the Curious Lawyer program. And we're looking at the first 10 amendments to the United States Constitution and just doing a 1-hour program on each of them so that you can learn and know, remember from law school perhaps. Perhaps you never touched some of the amendments in law school. I know I never touched the Third Amendment in law school, but we've got you a program on it. And this is your chance to really fill out your knowledge on those first 10 amendments. We do this in a very non-partisan manner. It's just the straight facts in terms of how the case laws come down and what's going on. We're not getting involved we will highlight the debates for you, but we're not taking positions. Certainly, we want to educate you on the Second Amendment today. So, let's get started, and let's start, of course, with the Second Amendment. And here you have it up in front of you. A well-regulated militia, being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. We will keep coming back to this language today, but that is the amendment. It is short and simple, but has spawned much uncertainty, as you will see, over the last 200 years, and certainly much litigation in the last 20 years. So let's take a look now on our next slide at the issues that we will address today as we walk through this program. We're going to look a little bit at the historical scope and the rationale, the purpose, the goal, the debates around that. We will look at the substantive nature of the Second Amendment in terms of Supreme Court cases that have touched it. We will also look at the changing landscape, really, from the Supreme Court of the United States in terms of what exactly is the right and what is the standard by which an infringement of that right is judged. What is the standard, in other words, by which we judge state or federal laws that touch the right within the Second Amendment? We will also look at a whole patchwork of different state laws that are all different, that are touching different areas of gun regulation, from background checks to assault weapon bans to advertising and marketing laws that are becoming more and more prominent in certain states. And we will look at some new technology in terms of the modern world and the rapid advances we have, for example, 3D printing that enables what are known as ghost guns to be made, and how the law is trying to keep up with that and how the Second Amendment may interface with that. And of course, because this is the Curious Lawyer program that's fun and entertaining for you, we will raise a fascinating question that was raised by Chris Rock 20-odd years ago in one of his hilarious comedy skits about whether we can tax bullets. So stay tuned, you'll see that 1-minute clip from Chris Rock in a little while, and then we will explore, is the Chris Rock law a law that could be enacted by a state or a local jurisdiction and put on the books? What would happen? Stay tuned for that. So let's get going, and let's go back to where we've already been, and let's go back to the text of the Second Amendment. Now this time on this slide, you see we've got some of it highlighted in yellow and some highlighted in red. A well-regulated militia being necessary to the security of a free state. That's our red language. Now what we've highlighted in yellow is the right of the people to keep and bear arms shall not be infringed. And so one of the questions this raises is, are these two parts? Are they one part? What is the meaning of the red language? Is it modifying somehow and limiting the yellow language, or is it simply an illustration of one purpose among many that may shed light on the right of the people to keep and bear arms? Those are some of the linguistic questions that have been raised and have now, to a large extent, been resolved as of 2022 in terms of the Bruin case, which we will talk about in great detail shortly, in terms of how expansive the right is and whether it was tethered, historically to something different. But let's keep moving along, and let's now get back in time to the historical context. And so we're going to go back to colonial America at this point. And we have the situation of, obviously the colonies were occupied by British standing armies of troops. There were thousands of troops in Boston for a mere 16,000 population. There were 4,000 troops, which is a staggering number of troops if you think about it. I mean, it's all but, a military encampment in the city. And they were there to crack down on dissent. And so citizen militias at the time were sort of the virtuous bulwark of the people against those standing armies, and militias were seen to serve that purpose. And at the same time then, in 1689, in Britain, there was the British Bill of Rights, and under its Article 7, it proclaimed, quote, that the subjects which are Protestants may have arms for their defense suitable to their conditions and as allowed by law, end quote. Now that forms some of the backdrop as we get to the Constitutional Convention in 1776, with the Bill of Rights, of course, added in 1791 with the Second Amendment. And the state constitutions at that time had different individual rights to self-defense or to the right to have militia armies within those different states. And so there was this sort of debate between the Federalists and the Anti-Federalists at the time about what should happen in the U.S. Constitution. The Federalists raised the question, how do we protect this new nation in terms of national security? We have a national government. We need to protect it, from foreign enemies and even from domestic enemies. And so we need issues like taxing and standing armies coming into focus now that we've got this unified nation that's being formed. And the Anti-Federalists, of course, were fearful of power leaving the states and going into the hands of a central government, and militias leaving a state and going and becoming the extreme province or the only province of the central government without the absence of protection against the existence of standing armies. And so that was some of the debate that was going on at the time in terms of what should happen. And so the Second Amendment then is enacted, and it didn't eliminate standing armies, but it did address the fears of a standing army disarming the people by protecting the right to have arms and the existence of state and local militias to protect against standing armies coming in and disarming people. So that's sort of some of our historical context that lets us now get to the first Supreme Court case that ever touched the Second Amendment, and that brings us to the case of United States versus Cruikshank, 92 U.S. 542, and this is an 1875 case. And so here's the background of the case. The case comes out of the Civil War amendments and the post-Civil War period, and you have in 1873 in Louisiana what's now known as the Colfax Massacre of 1873. And what happened basically is that in Louisiana there was an election, and two parties each claimed victory in that local election, and they each tried to take control of the Colfax courthouse. And so you had Republicans were with African American militias of the time, and they succeeded in taking the courthouse. A white mob then comes and it burns the courthouse down, and about 100 African Americans were killed as they were fleeing the insurgents against the courthouse. Now, the massacre leaders were prosecuted in federal court and they were convicted. And so this case eventually went up to the Supreme Court, and the Supreme Court threw out the federal counts and basically made clear that the victims, if they wanted any justice in the courts, it would be found in the state courts, and that was the place to go get it, not in the federal courts. And in the context of that case, the Supreme Court then passed on the Second Amendment and said, and you see here the quote, "The right to bear arms is not granted by the Constitution, neither is it in any manner dependent upon that instrument for its existence. The Second Amendment means no more than that it shall not be infringed by Congress and has no other effect than to restrict the powers of the national government." So what you see is that's a very, very important quote and a very important context to what the Supreme Court was saying in 1875 about the right to bear arms. And what it echoes is sort of a natural law rights concept, that it's not a right that was only in existence because the Constitution granted it to people. It exists because people had it as a right of theirs, independent of the federal Constitution. And so how it functioned, as the Supreme Court said in 1875, really is that it is a right that Congress can't infringe, and it can't be used to, the powers of the federal government can't be used to restrict that right. And so that was a statement that the Supreme Court made in that case, and that was sort of the word in 1875. And it wasn't really until we get to the next century that the Supreme Court again touched on the Second Amendment. And so this brings us to our next slide, where we will talk about the Miller case. So this is now in 1939, and we have United States versus Miller, as you see up here on our slide, reported at 307 U.S. 174. Now, this is a case that comes out of a statute passed in 1934, and this was the first federal gun law from Congress. It was the National Firearms Act, NFA. And the NFA banned sawed-off shotguns. And a man by the name of Miller was convicted of transporting sawed-off shotguns. Now, when he was convicted of this, he argued that this federal statute regulating and banning sawed-off shotguns abridged his Second Amendment rights to possess and transport across state lines sawed-off shotguns. And here's the quote from the Supreme Court in Miller. "The Constitution, as originally adopted, granted to the Congress power to provide for calling forth the militia to execute the laws of the Union, suppress insurrections, and repel invasions, to provide for organizing, arming, and disciplining the militia, and for governing such part of them as may be employed in the service of the United States, reserving to the states respectively the appointment of the officers and the authority of training the militia according to the discipline prescribed by Congress, with obvious purpose to assure the continuation and render possible the effectiveness of such forces. The declaration and guarantee of the Second Amendment were made. It must be interpreted and applied with that end in view." So now you see in 1939 a somewhat different, perhaps, interpretation of the meaning of that language, those two clauses we looked at and how they interrelated. And this is 1939, where the Supreme Court is now making that interpretation. And of course, this case comes out of the massive New Deal legislation that was occurring, many of which cases obviously went up to the Supreme Court of that era. But that's how the Supreme Court framed, at least, its then understanding of the Second Amendment and how it worked. And so if we go to the next slide, we can learn what happened to Mr. Miller. And here's what the Supreme Court held. "The Second Amendment does not guarantee an individual the right to keep and bear a sawed-off double-barrel shotgun. Because possessing a sawed-off double-barrel shotgun does not have a reasonable relationship to the preservation or efficiency of a well-regulated militia, the Second Amendment does not protect the possession of such an instrument." And that was a unanimous decision. So what you can see there is that if you remember back to our slide in the beginning where we looked at the red language, a well-regulated militia being necessary to the security of a free state, and we looked at the yellow language, the right of the people to keep and bear arms shall not be infringed. And we asked the question, what is the relationship between the first clause and the second clause? Is the right of the people to keep and bear arms somehow tied to and within the context of enabling a well-regulated militia? Or is a well-regulated militia simply but one example of the reason we have the right to keep and bear arms? And so you see here in Miller, the Supreme Court affirming Congress's legislation and really tying those two clauses together more in the context of the right to keep and bear arms is a function of the importance, as you see on the slide here, of the guarantee of the individual to have that right because it may possess some reasonable relationship to a well-regulated militia. And if it doesn't, then the government had the capacity to regulate it based upon that reasonable relationship or an unreasonable relationship. And so you see there a tying of those two clauses and a methodology in terms of how the Supreme Court was looking at the Second Amendment in the 1930s. So that was a unanimous decision in 1939. And so really that is the last word until the very modern era. And so basically what we have is from the founding of the Republic and from the passing of the Bill of Rights and the Second Amendment in 1791 until 2008, the Supreme Court never once declared unconstitutional any law, whether it be federal, state, or local, as violating the Second Amendment. And that's the way things stood until we get to our modern era. And so that brings us to the 21st century, when the Second Amendment has now become a new burgeoning area of litigation and Supreme Court decisions. I think it's safe to say we've had more Supreme Court decisions on the Second Amendment in the 21st century already than we had in the prior 2 centuries of the Republic. And so that's why this is such a great program for us today, because probably 10, 15 years ago, we couldn't have even done a 1-hour program on the Second Amendment. We would have just finished it. But let's keep going. So now this brings us to 2008. And this is the Supreme Court decision of the District of Columbia versus Heller. It was a 5-4 decision in 2008. And so let's start with the facts. Heller dealt with a District of Columbia gun regulation that prohibited an otherwise law-abiding gun owner from keeping an unlicensed, operable weapon in his home or her home for defense of the dwelling and the person. And so this law was challenged, and it was taken up to the Supreme Court, and the majority quote is as follows: "The Second Amendment protects an individual's right to possess a firearm unconnected with service in a militia and to use that arm for traditionally lawful purposes such as self-defense within the home. The Constitution leaves the District of Columbia a variety of tools for combating that problem, including some measures regulating handguns. But the enshrinement of constitutional rights necessarily takes certain policy choices off the table." In addition, the Supreme Court wrote, "Like most rights, the right secured by the Second Amendment is not unlimited. It is not a right to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose." And so there was some sort of a means-end type test the Supreme Court used. It looked to history, but it also noted that it failed under a version of means-end scrutiny testing. And so basically what the Supreme Court held is that you have presumptively lawful laws that may prohibit firearm possessions by dangerous people. You can forbid firearm possessions in sensitive places such as school and government buildings. You can impose conditions on the commercial sale of firearms, and those types of laws would be presumptively lawful, the Supreme Court held. But what you see very importantly here in the majority quote there, and this decision was authored by Justice Scalia, is now a different interpretation of our two clauses. Whereas we saw in Miller more the concept that that laws abridging your right to keep and bear arms would be assessed and analyzed with some tethering to this well-regulated militia clause. Now you have Justice Scalia writing for the Supreme Court saying that this right, quote, protects an individual's right to possess a firearm unconnected with service in a militia. It's a personal right. And so that changes or begins changing the landscape of the Second Amendment. And so what the Justice Scalia wrote and what the majority said is that that first half of the Second Amendment, again, our red language, about militias was the prefatory clause. And that was the quote that comes from Heller. And the latter half is the operative clause, protecting a right of the people to keep and bear arms. And a prefatory clause could not limit the meaning of an operative clause. And that canon of construction and that approach to the construction of the Second Amendment meant that the Second Amendment protects a right to have guns in the home for the sake of security. And a law that says you cannot have an unlicensed gun in your home for self-defense would fall under that standard. Now, what Heller left open was that there was no prescribed level of scrutiny in terms of the analysis. It also made clear the Second Amendment is not absolute because it gave those examples of presumptively lawful laws. But it didn't really answer exactly the question of how do we assess methodologically and test the laws? Do we use our traditional means-end testing that we see, for example, if you take the other Curious Lawyer programs on the First Amendment or when we look at the 14th Amendment and equal protection and we talk about strict scrutiny, intermediate scrutiny, rational basis review, and we use those levels of scrutiny in terms of means-end testing to look at whether a law is lawful or unlawful under the Constitution. But nonetheless, that's where we stood with Heller in 2008. So that now brings us to another very, very important question that we talk about in all of our Curious Lawyer programs, and that is the incorporation doctrine. You may remember it from law school or from the bar exam, and if you didn't have it in law school or the bar exam, you get it now. And so the question the incorporation doctrine raises is, does the Second Amendment apply to the states? And the idea, of course, comes from the fact that the protection of the constitutional amendments, the first 10, that had applied only to the federal government up until the Civil War, and had not applied to the state governments. And so these were prohibitions and restrictions on federal governmental behavior as opposed to state governmental behavior. And so the question then raised after the Civil War and after the passing of the Civil War amendments is whether the 14th Amendment's adoption and its due process clause incorporated the first 10 amendments and made them applicable now to the states by virtue of the 14th Amendment's limitations and regulations upon the states. And so that question has had to be answered by the Supreme Court in all contexts in terms of whether all the various amendments have been incorporated and apply. And so the basic test that the Supreme Court uses and adopts to assess this question of incorporation is the idea that fundamental rights rooted in the tradition and conscience of our people, and thus implicit in the concept of ordered liberty, are applied to states via the 14th Amendment. And this comes from the Griswold case from the 1960s. And you see the citation there. It's 381 U.S. at page 499. You can learn all about the Griswold case in our other programs. If you're interested in watching more of our Curious Lawyer programs, it's a fascinating case. But nonetheless, the result is that all but a few portions of the Bill of Rights have actually been incorporated through the 14th Amendment and applied to the states. Now, the Second Amendment, it had never been addressed whether it applied to the states until we get to 2010, where right on the heels of our 2008 decision in Heller, the Supreme Court took up a case to look at whether the Second Amendment would apply to state and local governments. And here they looked at a local law, Chicago City Ordinance, that effectively banned all private handgun possession. That brings us to 2010, McDonald versus Chicago. Now, this case, like Heller, was a 5-4 decision, and it dealt with and confronted a Chicago ordinance that banned gun possession in the home. The majority wrote that the governing standard is whether a particular Bill of Rights protection is fundamental to our nation's particular scheme of ordered liberty and system of justice, coming from the Griswold contraception case that we just looked at. And here's the quote. It is clear that the framers and ratifiers of the 14th Amendment counted the right to keep and bear arms among those fundamental rights necessary to our system of ordered liberty. A provision of the Bill of Rights that protects a right that is fundamental from an American perspective applies equally to the federal government and the states. The subpoint here, of course, is that self-defense is a basic right. It's recognized by many legal systems from the times of our ancients to the present and everywhere in between. And the Heller Court basically held that the individual's right to self-defense is really the central component, and that's a quote, central component of the Second Amendment right. And so the result is that McDonald held that the Second Amendment does apply to state and local governments. And so it answered the incorporation doctrine question for the Second Amendment that had been lingering for over nearly a century and a half since the passing of the 14th Amendment. We finally got the answer to the question whether the Second Amendment in fact applied to and functioned as a limitation on state and local government abilities to pass laws regulating the right to keep and bear arms, regulating gun ownership, regulating all manner of gun-related issues. And as it turns out, like most of the Bill of Rights, it's been incorporated, and so it does apply to state and local governments. So now on our next slide, let's take a look, before we get to 2022, at sort of an overview of the regulatory environment as it relates to guns. And here is a really fascinating couple of maps in terms of 2021 data, in terms of states that have background checks on gun laws and states that have child access prevention to guns laws. And so what you see here on the left chart is a map of the United States, and you have color-coded categories, 4 of them, in terms of what background checks exist and what kinds of background checks exist across the board in different states. And as it stands in 2021, 100% of states have background checks. Now, part of this is because background checks for sales from dealers is a federal law that applies everywhere. You have background checks for sales from dealers only in some states, as you can see. You have background checks for private sales in some fewer states, as you can see. And you have background checks for permits to purchase in some other states, notably Hawaii and some of the East Coast states. Now, if we look at the other slide on the right, we see that about 61% of the states have some form of child access prevention gun law. Now, these state laws that are designed to prevent child access to guns take on various kinds. You have ones that prohibit, reckless behavior and, punish someone if they recklessly allow a child to access a gun due to reckless storage. Some laws have a lower standards, such as negligence. If you're simply negligent in terms of how you maintain and store your gun, and the child gets the gun and something happens, you face liability. And you can see the map here in terms of the 61% of the states that have those laws. Most of them have, of the states that have laws, most seem to have a negligent storage standard as opposed to a reckless standard. But a significant number have a reckless standard also, and some don't have any standard. And that would simply mean that within the context of those states at least, it hasn't been enacted and codified as positive law, but in the other, 39% of the states that don't have actual statutory law, it may well wait to be litigated as to whether the common law of negligence would impose, standards that may or may not apply. Now, that brings us to 2022 and the Bruen case. And the Bruen case came down, of course, in 2022 as a 6-3 decision. And the focus of the case was the public carry laws. And this comes out of New York. And this is sort of the area of much litigation across the country in all jurisdictions in terms of looking at all the different state laws that regulate public carry. And you have permissive public carry, you have highly regulated public carry, and the basic question is, different states have enacted different laws that place varying restrictions or burdens or limitations on one's ability to carry publicly a gun. So, whether I can have a gun inside my jacket while I'm walking around on the street is something that varies greatly by state. And New York had, like California, several of the states have had historically more onerous laws that make it more difficult for people to gain the right to publicly carry. And so New York's law basically posited that anyone who wanted a concealed carry license to carry a gun in New York needed to demonstrate that they had proper cause for the license or a special need for self-defense. So it would be something highly particularized or some high proper cause standard that they had to get over a bunch of hurdles to justify having a gun, as opposed to presumptively having the right to carry a gun unless they had perhaps done something to trigger a reason that the state could regulate and take that away. And so that's sort of the collision of the standards. Now, if we go to the next slide, we'll see how the majority approached it. And the majority indicated that the Second and 14th Amendment fundamentally protect an individual's right to keep and bear arms. And as it explained, bear encompasses public carry. That the concept of the Second Amendment, when it talked about bearing arms, wasn't tethered only to home self-defense within the home only. That bear would encompass the idea of public carrying given the history of the time. And so what the Supreme Court said is that if the plain text of a state law at issues covers an individual's conduct, then the Constitution presumptively covers it. And it's not simply enough for the government, New York State that is, trying to justify its law to come forward with a very important reason for the regulation. In other words, what the Supreme Court said is that even if you have, New York, a compelling reason and you come forward and you make all these great arguments, that's not enough. We're not going to apply that kind of a scrutiny analysis to say that this right can be abridged. The right exists, the Constitution presumptively covers it. And so instead, if the government, the state, if New York, in other words, in this case, wants to show that its regulation, its proper cause standard is consistent with a restriction on that Second Amendment right, then it needs to show that that regulation is consistent with the nation's historical tradition of firearm regulation. And that's at 142 Supreme Court at 2130 to 2131. Now, this is bolded here for you because this is a very, very significant development in jurisprudence, in our constitutional jurisprudence of the Second Amendment, and in the method by which courts have to now analyze state or local laws to assess whether they're constitutional. And it's really critical because it's this shift from the idea of, does the government have a good reason to regulate someone's right to possess arms? And so if the government shows a really good reason, a court says, okay, fine, we defer to that reason under kind of traditional, and types of analyses. But instead now what we're looking at is, if a regulation is to stand, then the regulating body, the state or local government, whether it's New York State or the city of Laguna Beach, wherever it may be, right, needs to establish that its regulation is somehow consistent with historical regulations, that this type of regulation existed in the past and was part of the patchwork of firearm regulation in at the time of the nation's founding. And so on our next slide, what we raise the question here is, do we have a new constitutional analysis? And it seems we definitely do. We have a new methodology by which courts need to address Second Amendment problems and approach them. And it's really fascinating and critical, and this is why it's such a great program for you as a curious lawyer, because it's a new way of doing and conducting and assessing constitutional analyses, and it's going to spawn a whole new area of litigation. It already has, as we'll see shortly, a whole new approach to assessing and analyzing and making arguments, which is now viewed through the prism of history. And so, fascinating area. If for any of us who may be fortunate enough to litigate in such an area at some point, we are digging through history now and doing a historical analysis and arguing then about what laws were in existence in what areas at what time and what those laws meant. It's sort of this lawyer archaeology exercise in excavating old laws and understanding what they were. Incredibly fascinating stuff for us, if we're a historian lawyer, archaeohistorian lawyer, we could say. Now, this is the historical inquiry. Quote, this historical inquiry will often involve reasoning by analogy. Analogical reasoning requires only that the government identify a well-established and representative historical analog, not a historical twin. So even if a modern-day regulation is not a dead ringer for historical precursors, it still may be analogous enough to pass constitutional muster. And so this is such a unique inquiry. It doesn't really exist particularly in this form in other areas. What the Supreme Court went on, and that was at page 2133, as you see on our slide, the Supreme Court went on to enable courts to assess which similarities are important, and this is in this historical analog analysis of looking at historical laws, but in other words, to enable courts to assess which similarities are important and which are not during this analogical inquiry, they must use at least two metrics, which are central considerations to that inquiry. And so here are the two metrics. Whether modern and historical regulations impose a comparable burden on the right of armed self-defense, and whether that regulatory burden is comparably justified. Now, what the Supreme Court also noted is it's not just free rein, where you can do and say anything. There is limits here, and part of the limit the Supreme Court at least noted, and it to be fleshed out in future cases, of course, is that you cannot simply endorse outliers that our ancestors would have never accepted. So there may be outlier laws that one finds. We may go back to the year 1800 and find an outlier law in some town in Massachusetts, and that doesn't necessarily set the stage for what was accepted regulation or limitation on gun possession or self-defense rights of the time. And so there is this need to sort of assess in this historical analogical inquiry whether the law you're looking at was truly reflective of the understanding of the people at the time, or whether it was really an outlier. And so as a result now, our courts and lawyers and litigators must look to historical laws and see if those historical laws placed a similar burden on the gun regulation at issue today. Now, what time period is a very, very important question. Do we look at only the state of gun regulation laws in sort of 1791 at the adopting of the Second Amendment, or do we do this inquiry more focused on post-Civil War when the 14th Amendment was adopted and then therefore incorporated the Second Amendment back and made it applicable to the states? And so at that point, do we want to understand, since it's at that point that the Second Amendment is applying to the states, do we want to look to historical analogs at that time period? The exact answer to this question wasn't decided. The Supreme Court didn't address whether you only look to 1791 and not 1868, or vice versa. We only are concerned with 1868 and not 1791. They certainly looked at a whole bunch of laws that went back before 1868. But whether and where we banned this sort of time-wise wasn't definitively decided. And Justice Barrett's concurrence notes that it's still open as to whether courts should look to regulations from 1791 or 1868. And that's an important concurrence, noting that this is just still an open question. Now, one thing that definitely comes out of this, which is particularly important for those of you who may be litigating in this area at some point, is this will become an area that is very, very important to have experts in. And so here's a practice pointer. There are experts who have spent years as historians studying and analyzing the history of gun regulation in the United States and in the republics and in the republic and pre-republic colonies. And that becomes a very important source of material to go to look at and to have as a tool for you as a litigator, because you won't, as a litigator, necessarily be able to just do what we normally do, which is we're posed with a legal question, we log into Westlaw, and we punch in the search, and we look in a database of, this state or that state, or federal, or a circuit, and we look for laws or case law. This isn't really going to work in the same way, because we are now talking about very, very, very old laws in a variety of state and local jurisdictions that have to be discovered and assessed. And it's just a different area of inquiry. It's really an area of inquiry that needs one to, from a research perspective, dive down a different well. For those historians, it's going to be a great time of earning a lot of money for their expertise as they get retained and hired on different sides of these fights to sort of provide the tools for lawyers to sort of be able to find laws, quote laws, and argue about whether they are, appropriate historical analogs or not, all of which then gets funneled into the courts. So that is this very new constitutional analysis we have. It's incredibly fascinating and interesting. And of course, there was a dissent in Bruin, and our dissent was from Justices Breyer, Sotomayor, and Kagan. And Justices Breyer, Sotomayor, and Kagan argued, as you see on our slide here, that the appropriate methodology to assess government action should have remained the sort of traditional means and testing done in other areas of constitutional law, where we look at how courts evaluate other constitutional rights that collide with regulatory behavior of local, state, and federal government. And so one of the points that the dissent made is that we are historicizing concepts of justice to a different time by a select few, and we're binding ourselves today to old concepts of sort of justice or law or what was occurring at the time, and that was rejected by the dissent. And from a practical point, that was more of a policy rejection of where the majority of 6 were. From a practical sort of litigation practicality type perspective that's less policy oriented, the argument made was that this tradition test is impractical and difficult for courts to apply because courts don't really have the resources to conduct historical analog assessments. And fundamentally, scavenging through that kind of history allows judges to, at the end of the day, find anything to justify outcomes on either side. And so what they were basically saying is that a state may have some very, very onerous regulation on the right to possess a gun. And if you look in certain places in certain ways and slice and dice it, you may find some old state laws that allowed and justified that. And then a court can say, yep, this huge regulation on the right is perfectly acceptable because I found these historical analogs. And another court may go and look at different historical analogs in different states and say, no, that same conduct was never allowed to be regulated in that way. And so it is therefore an unlawful regulation today. And it becomes a game of sort of this historical analog game in terms of how we identify, find historical laws, how we look at them and generalize them and abstract them, because of course the laws of the day weren't necessarily talking about exactly the same things that we're talking about today. In other words, there may have been laws hundreds of years ago dealing with possessing muskets to deal with people coming to steal livestock on your property, which would be out in the open. And today we may be talking more about possessing guns in a 20-story building for self-defense. where we have police and, there weren't police to help in the old analogs, and sort of how do you harmonize those and how do you abstract them at very, very specific levels? They may look very different, but if you abstract them enough, you can make them very, very similar. And that is sort of the practical argument made by the dissent. And so the dissent then looked at a history of laws that they saw as being relevant to this New York law at issue, and they said that their version of history justified the state law. And so they did that in essence, to point out this practical difference, that history can be in the eye of the beholder, and we're adding a layer of complexity to constitutional analysis for courts. And so that's sort of where we stand in Bruin in 2022. Now I have a short clip here for you to watch. It's a 3-minute clip. I tried to find the least partisan clip I could find here. It's a speaker who simply is sort of outlining the different visions of what's just happened in this Bruin case as we've been discussing. And I thought I'd leave you with that to try to solidify and set that playing field before we now march forward into what are the limits of Bruin and what's going on now in the post-Bruin world and what we will be confronting. So watch the video clip.
Obviously, this one got buried because we've been talking so much about the abortion decision, but this decision expands the Second Amendment right to bear arms to include outside the home. Help us understand this opinion and what it means for gun rights and gun control measures, as well as legislation like assault weapons bans.
Well, it's a tremendously important decision, Ali, and it's very important that viewers read the decision themselves, both the majority opinion and the dissent. I'm going to summarize both of them, and then I'll give you a website for excerpts from the decision. So the majority strikes down, as you said, New York's may issue concealed carry regime, which requires a special need for a concealed carry license. And in doing so, the court said that under the Second Amendment, you have the right not only to keep a gun in your home, but also to carry a handgun for self-defense outside the home. And in his majority opinion, Justice Clarence Thomas focused on the history and tradition of the Second Amendment. Basically, he asked, does historical precedent similar to the New York law exist before, during, and even after the founding era? And Justice Thomas's answer is no. He said, we find no such tradition in the historical materials. In a very vigorous dissent for the 3 liberal justices, Justice Stephen Breyer criticized Justice Thomas's history and tradition approach. He said judges aren't historians, and it'll be too easy for them to pick their friends out of history's crowd. In other words, to cherry pick the historical record for evidence that supports their views and ignore evidence that doesn't. He also worried that this historical approach would prevent states from flexibly adapting to new procedures posed by new technologies. He had one very memorable line. He said, laws addressing repeating crossbows, launce-gaze, dirks, daggers, skeins, still ladders, and other ancient weapons are of little help to courts confronting modern problems. So what does this mean for gun control in America, as you asked? Well, for starters, New York and 7 other jurisdictions with may issue regimes, these discretionary regimes, which represent about a quarter of the country's 84 million people, will have to switch to shall issue regimes, which means that applicants will get a concealed carry permit as long as they meet the criteria. Under Justice Thomas's approach, it is still possible for states to ban dangerous and unusual weapons and to ban guns in sensitive places, but what counts as a dangerous and unusual weapon is up for debate, and in fact, courts are already beginning to divide about whether or not assault weapons bans are permissible under Justice Thomas's approach. Ali, as I said, it's very important that viewers read the majority opinion and the dissent on their own. A great place to start is the National Constitution Center's We the People podcast, where we did an excellent debate about the Second Amendment decision, and we're also posting excerpts from the majority opinion and the dissent on our website, constitutioncenter.org.
Bruin does not undo the licensing requirements such as fingerprinting, background checks, and training that exist in many states in order to possess a firearm, nor does it repeal the prohibitions that exist under federal and state laws regarding who's qualified to possess firearms. It didn't do anything in that area. That will be the subject of future litigation. But Bruin does undo the types of gun restrictions that were addressed in both the Heller and McDonald cases that we looked at earlier from 2008 and 2010. Principally because the Second Amendment does not entitle a person to keep and carry any weapon whatsoever in any manner whatsoever and for whatever purpose. The decisions recognize the legitimacy of long-standing prohibitions on who can possess firearms and forbidding their possession in sensitive places such as schools and government buildings, and specifically noted these regulatory measures were only examples and not exhaustive. Thus, many laws are presumptively constitutional, like prohibiting certain people from possessing guns, or regulations on the commercial sale of arms. And Bruen didn't undo those earlier holdings. And so Bruen didn't, in other words, say it's open reign, anyone can run around and do whatever they want with a gun in public, and it's all okay. Bruen didn't do that. We still have this idea from McDonald and Heller that there's presumptively and appropriate ways that states can impose some sort of structure in terms of open carry laws, for example, for self-defense. But Bruen certainly requires ultimately revisiting many of those state laws. I mean, many states have had more restrictive carry laws like New York, which certainly have to be revisited as a result, given the new litmus test is built around looking at whether gun regulations comport with traditional American practices of gun ownership and regulation. Now, let's take a look at what's already happened, because this is an area of fast-flying litigation. I mean, Bruen came down in June 2022, and we're not even at the end of 2022 filming this for you, and we already have a bunch of post-Bruen state laws that have been enacted and subjected to challenges under this new methodology. So it's fascinating. We even now get to look in real time at how this is playing out. And so after Bruen, New York immediately passed state laws attempting to comply with Bruen, but also continue to limit public carrying. They listed sensitive locations by the statute where one cannot carry, including places of worship, educational institutions, courthouses, federal, state, local government buildings, polling sites, public transportation, such as subways and buses, daycare facilities, entertainment venues. You see the full list there, a whole bunch of different places, even down to Times Square. And for privately owned property and premises, such as office buildings, the default law continues to say that a person may not carry a firearm into those premises unless the owner has posted a conspicuous sign indicating that the carrying of such arms is allowed. And so, as you see on our next slide, again, continue to look at these post-Bruen state laws from New York. They further expanded the requirements for a concealed carry permit by requiring 4 character references, firearm safety training courses, live fire testing, an in-person interview, information on the applicant's former and current social media accounts from the past 3 years, in addition to background checks. The new law also expands the disqualifications for receiving a concealed carry permit by excluding individuals with documented instances of violent behavior, misdemeanor convictions for assault, weapons possession and menacing alcohol-related misdemeanor convictions, such as DUIs, recent treatment for drug-related reasons, and recent involuntary commitment to a mental health facility, as well as a renewal requirement every 3 years in order to have a public carry license. And so, on our next slide, we're going to look at what happened in federal court in the Southern District of New York after this law was enacted, because it was challenged, and it went on a preliminary injunction motion before a judge in the Southern District of New York. And you see here in October of 2022 what the judge held. The judge basically took each of these aspects of the New York state law that we just talked about and went and did a historical analogical model to assess and figure out whether they were appropriate. And so what the federal judge in New York said is that the good moral character, being the part of the burden of the permit seeker, couldn't find any historical analogs going back to old laws, and so therefore such a standard falls and is not an appropriate thing for a state to do. Similarly, being required to identify all the people who are in your home or list your social media accounts over some prior period of time didn't have any historical analog. Obviously, on the social media front, you never could find a one-to-one law, but they looked to find sort of things that you could argue of level of generalities would be historical analogs to sort of public posting or notice of people to the local community. And the court there found there was no historical analog to justify New York doing that. On the 18 hours of firearm training, the court found that there were historical analogs that were acceptable and appropriate, and so New York could require 18 hours of firearm training. And the court then looked at sensitive restriction locations and went through that whole list of different locations to figure out for each one of those various locations what historically had happened. And so the basic holding of the Southern District of New York is that the New York sensitive restriction locations where you could not have a concealed carry right were by and large okay for most of the locations except for people tasked with keeping peace at religious services. So, if you have people who are required to keep peace at public services that are religious in nature, then those people, based on historical analogs, can have concealed weapons in the religious services or locations. Cars were places that, given historical analogs, people could possess concealed weapons. And the court found that entertainment venues where alcohol was present did find historical analogs allowing people to have concealed weapons. And so an injunction was issued enjoining much of the law, but allowing parts of the law to stand. And that is the case of Antoniuk et al. Versus Hochul et al. It's at 22-986, October 6, 2022. You can find the decision if you punch it into Google. Absolutely fascinating decision to really spend some time reading if you're particularly interested in this new methodology of legal analysis. It's absolutely fascinating in terms of legal analysis merging with historical analysis and seeing how the court took every very, very specific instance of the New York law and then traced, based on the parties briefing, battling, arguing over what laws they thought applied and didn't apply, what the outcome should be. Incredibly fascinating stuff. Now let's shift to California, and we're going to look at some post-Bruin laws and what's going on out in California as a result of Bruin. And the Bruin stone dropping in the lake has created loads of ripples everywhere across all different laws and litigation that was already in existence pre-decision, but it's had a profound impact and cast a big shadow. So let's start with the case of Boland versus Bonta. And the California Rifle Pistol Association sued to overturn California's 1999 Unsafe Handgun Act, which had established safety standards for handguns. If a pistol is deemed unsafe, it can't be sold by licensed dealers. And so in this case, the plaintiffs contend that the regulation wouldn't pass this history and tradition test set forth in Bruin. And there had been two prior attempts to void the law, but they had failed in the pre-Bruin era. And so that is one case that's now pending and percolating in the courts. We are going to do another Second Amendment program for you in a few years. So when you're next up cycling to get your CLE, come back and look for the Curious Lawyer in the Second Amendment, because by 2025, we're going to have a lot more to say, I'm sure. We'll see what happened with Boland. Jones v. Bonta. Post-Bruin, the Ninth Circuit had a pending case, and it reversed its decision that had found California's semi-automatic rifle ban for adults under 21 unconstitutional. The ban is now back in play, but this was remanded in light of Bruin's new methodology for deciding gun cases. And so this question of whether California's semi-automatic rifle ban for people under 21, whether it's constitutional or not, now has to be reassessed by the district court through the Bruin prism, the historical analog prism. And we have Rode versus Bonta. This is a state law that prohibits direct mail order ammunition sales and has ammunition background checks at point of purchase requirements, and these were challenged as unconstitutional. The district court held that California's new ammunition background check law misfires, and the Second Amendment rights of California's citizens have been gravely injured. Now, on appeal, the Ninth Circuit is now asking for supplemental briefing in terms of Bruin's impact to understand how do we assess the district court's conclusion in light of Bruin as we look at this state law that's prohibiting direct mail order ammo sales. Let's also look post-Bruin at the federal laws, because we have, in the wake of Bruin, the Federal Bipartisan Safer Communities Act of 2022 was enacted, Senate Bill 22938. And this new federal law says that individuals with misdemeanor domestic violence convictions, which includes not just being married but also being in dating relationships, cannot possess a firearm when you've had such a domestic violence conviction. And on the mental health front, the federal law says that when a background check is performed for a purchaser under 21, the FBI's National Instant Criminal Background Check System must now investigate if there are juvenile records in the buyer's home state to see if there's a disqualifying event. Such records will include felony and misdemeanor domestic violence convictions, and involuntary commitment to mental health facilities after the potential purchaser turns 16 years of age. The new federal law also is known as the gun show loophole closing law. And here it provides that a federal firearms license must be acquired by anyone, not just with the principal objective of livelihood and profit, which was the old standard, now to anyone selling guns to predominantly earn a profit also. And this sort of ended the ability of certain folks to sell guns at gun shows and get around the background checks because it wasn't their principal livelihood. It's now, if you're earning a profit and that's what's going on, then you've got to go run a background check. And so the question now, of course, will be that federal law, are all of those aspects consistent with historical analog laws in terms of regulations and limitations on gun ownership and gun possession? And most of them probably will be when you look at some of now the percolating litigation that's kicking around the old historical analogs, but some of them may fall, and we will find out soon. Now, the next slide, we're going to ask the question, what counts as arms? Remember, the Second Amendment said a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. What's an arm? Well, we can ask the question, what about state laws that are regulating possession, say, of weapons of mass destruction, tanks, Scud missiles, or other such sort of very, very different modern weapons? Any such state law has to be subjected to a historical analog test now. And so historical laws limiting possession, perhaps of that era's most significant weapons, will have to be assessed to look to see where were the lines drawn at the founding or in the 1860s under this historical analog test when it came to what kind of historical regulations existed. People could possess certain arms but not others. I mean, in other words, were there laws that were on the books at the founding that perhaps said people have the right to have, muskets and those types of weapons, but they weren't allowed to have cannons because that really belonged to the militia or the standing army. Those types of laws will have to be assessed to see what limits can be placed on one's right to count and bear arms. And it will probably spawn further litigation about arms and the concept of arms, and maybe the court will now interpret arms in a different way if it finds the need to narrow and regulate the Second Amendment vis-a-vis more significant weapons. We will see. So here's an example, and this is a case that came before Bruin, obviously, but now is being reassessed. And this is the case of Colby versus Hogan. It's reported at 849 F. 3rd 114 in the Fourth Circuit for 2017. And this was a Maryland ban on AR-15s. And it was challenged, and the federal court held that the ban was acceptable because AR-15s are military weapons. And so the conclusion of the en banc decision of the Fourth Circuit is that an AR-15 is a military weapon, and it is not an arm within the Second Amendment to which you have such a right to keep and possess. And so Colby held ultimately that categorical bans like that can be constitutional for that class of weapons. But after Bruin, the Supreme Court has vacated it and sent it back to be reassessed in light of Bruin. And so this holding, and this is going to be a very, very significant case to watch for if you're interested in this area, is what will happen when the Maryland ban on AR-15s is assessed through the historical analog test? We wait and see. Now let's look at a fun little interesting area of where technology collides with this, and we have 3D printers, we have ghost gun laws. And so we have a federal executive order in 2022 dealing with homemade kits to make guns, and they have now been categorized the same as actual guns under the Gun Control Act of 1968. And that means that the main components used to manufacture ghost guns, frames and receivers, have to be assigned serial numbers. That's just part of the federal Gun Control Act, that there must be serial numbers on guns for tracing and tracking and for those purposes. And now that we have the ability to make guns in our own home, if you have a 3D printer and you can do that sort of a thing, the executive order at least requires that those main things be assigned serial numbers, and also then that buyers undergo background checks before purchasing those components, and that dealers be federally licensed to sell the kits and keep records of sales. And so if you want to start making guns via gun kits that you buy, it's falling into the same stream of commerce as guns in terms of tracking regulations, serial numbers, and the like. So this was challenged in North Dakota, and the U.S. District Court held that the rules were viable, They were not unconstitutional because they regulate the sales of weapons in commerce and require serialization for a weapon in commerce, even if it was homemade. But homemade, and this is a limit, but homemade for personal non-commercial use doesn't require serialization. Another fascinating decision from August 23, 2022. In the same space dealing with modern technology, we have California Assembly Bill 2156, which prohibits unlicensed individuals from using 3D printing to manufacture any firearm or precursor part, including for personal use. And so if you want to 3D print any part of a gun, even for personal self-defense, home use, you have to be licensed. So in other words, I live in California. I can't go buy a 3D printer and just make a firearm or a precursor part of a firearm in my home for fun or otherwise, because it would be illegal under AB 2156. And so that too will now be assessed and looked at in litigation to understand how we as a historical people regulated manufacturing, home manufacture of weapons, basically. Now, the other area that this leads to in terms of guns is regulating the marketing of guns. And here we have a California law that prohibits the gun industry from marketing firearm-related products to minors. And so this is a new and more developing, burgeoning area of law in many, many jurisdictions where the stakes are being raised in terms of marketing restrictions on the companies with very onerous penalties for engaging in marketing that's alluring to minors. And so you can think back to, for example, the tobacco litigation of the last 20, 30 years, where there were very significant and ever ratcheting up state laws punishing marketing towards minors of tobacco. Now it's the same for guns. And so the factors that are required to be assessed to figure out if there should be a penalty for improper advertising is the use of characters, firearm branded merchandise that kind of is appealing to minors, the color that's with it, and to the intent of the advertising campaign to appeal to minors, images of minors perhaps with guns in publications that minors look at, that type of thing. This was challenged under Bruin, and the Redlands California Youth Clay Shooting Sports and the California Rifle and Pistol Association went into court and said after Bruin that this regulation on them is unconstitutional, and they're, as a result, not able to promote and host target shooting events and firearm safety courses that involve signage, flyers, discussions, branded merchandise, and giveaways, and depicting minors enjoying their Second Amendment rights to possess and use firearms for lawful purposes. And so that's a quote from the complaint you see there. That has now been filed in 2022 challenging it. And so the question now will be, can California impose such limits on the ability of companies or organizations like youth organizations involved in youth shooting sports groups to limit the ability to market and target towards minors? That will be now looked at and assessed in light of Bruin. This now brings us to the moment you've all been waiting for, the Chris Rock question. Can we regulate bullets? Is a way around the issue of bearing arms and regulating guns? Maybe we don't need to regulate guns. We should just regulate bullets. And so there is this absolutely hilarious clip. If you've seen it, you know it, you're already laughing. If you haven't seen it, you're now going to watch it. It's about a minute. It's absolutely hilarious, but it's brilliant, and we're using it because it's part of the hilarious comic genius that these great comics have, to really raise then the question of, would a Chris Rock law that he talks about here be appropriate? Would it fall under the Bruin test, or would it stand under the Bruin test? What would we do? What would we look at? And so it's really a fascinating comedy skit from 25 years ago, I think the late 90s. Now, for those of you who haven't seen it, it has foul language, so I apologize in advance, but here's a clip. Let's go ahead and watch it.
You don't need no gun control. You know what you need? We need some bullet control. We need to control the bullets. That's right. I think all bullets should cost $5,000. $5,000 for a bullet. You know why? Because if a bullet costs $5,000, there'll be no more innocent bystanders. Be it. Every time somebody gets shot, you be like, damn, he must have did something. Shit, they put $50,000 worth of bullets in his ass. And people will think before they kill somebody if a bullet costs $5,000. Man, I would blow your fucking head off if I could afford it. I'm gonna get me another job, I'm gonna start saving some money, and you a dead man. You better hope I can't get no bullets on layaway. So even if you get shot by a stray bullet, you won't have to go to no doctor to get it taken out. Whoever shot you will take their bullet back. I believe you got my property.
All right, there you go. I love this. I just think it's one of the funniest things ever. But the question we've got to ask now is, would the Chris Rock law be constitutional? We have to then assess historically, of course, how were bullets treated? Were they part of your arms? Is it a necessary corollary? If you have the right to bear arms, you got to have the right to have a weapon, or the ammunition, for the weapon as part of arms. Historical analogs will look at that in terms of what have been the historical regulations on the munitions that go with weapons. That will certainly be part of the analysis that we would look at here. But if we actually did have what Chris Rock proposes, which is, imagine a state or a local jurisdiction says, in order to sell bullets in this state, each bullet is taxed at an additional $5,000 per bullet tax, or something like that, right? We can actually look to some Supreme Court case law to get some guidance on how those very specific targeted taxes on particular individuals or products would work. And it looks like such a Chris Rock law would probably fall under a First Amendment analysis. If you look to these two cases that we have on the slide here as an analog, how it would line up under the Bruin analysis, I don't know, because no one's litigated it. Maybe if a state comes along and enacts such a Chris Rock law, we'd all get to litigate it. It would be great fun probably to see how that would shake out. But you see these two cases here. The basic point is that these specific general taxes are fine, but very, very targeted taxes, such as the kind here on the press, really interfered with the press's role as a source of public information, and so violated the First Amendment. So if you have a targeted press tax that damages its First Amendment rights, that's not constitutional. Similar analysis would probably apply to the Second Amendment. Very, very targeted tax that interferes with the Second Amendment may fall too. So that's probably how Chris Rock law would shake out. Who knows? Here's our conclusions. The last 15 years, the Miller, Heller, Bruin line of Supreme Court cases, really have, as they've evolved over the last century, articulating the substantive scope of the right, have generated a massive new framework in 2022. And this tradition in history, right and regulation, as a manner of assessing infringement, has a completely new analysis away from the traditional means and scrutiny. It's a brand new way of looking and analyzing these questions. It's very important. We now have a lot of state gun laws that are in flux, and they're up for litigation. And this is a massive new burgeoning area of litigation. There's undoubtedly going to be more Second Amendment litigation over the next 10 years, and there probably has been in the last 50 years. We have modern technology that's looping itself in here and spawning additional legislation and attempts by states to sort of deal with what they perceive as the gun issues in the states. And of course, we may well get the excessive taxation on bullet question posed by Chris Rock. Thank you for watching our Curious Lawyer program today on our Bill of Rights series on the Second Amendment. Check out our other amendment programs and check out all the Curious Lawyer programs. I'm Peter Afrasiabi, and as always, email me if you have any questions. Thank you.